Hello friends, hi, hope you all are doing good. There's a very specific beautiful judgment which I want to pass on to you in this particular module. The particular judgment is of the Mumbai tribunal in the case of Golden Bella Holdings. And let me specifically take you to a specific question asked under here, as the particular moot point is on the beneficial ownership as used under the treaties. The term beneficial ownership is used for various sort of incomes, active as well as passive, in most and all of our DTAAs, and hence it becomes very important to understand whether for a particular fact pattern you are a beneficial owner. Well, let's say when there is an intermediate holding company in the structure, then whether a particular company is a beneficial owner of the income or whether there is a back-to-back arrangement. In this particular case, the AO had alleged that there is a back-to-back arrangement between the intermediate company and the parent company, and hence the particular intermediate company is not a beneficial owner of a particular sort of income, and hence the treaty benefit should be denied. So let me take you through a particular analysis through the questions raised and the analysis drawn. As a substantial questions which arises in determining whether there is a beneficial owner or not, the assessing officer had said that okay, you don't have dominion and control over the interest income, and hence I should make the particular sort of denial for the treaty benefits. However, for this particular claim, he had not substantiated his position as to on what parameters and on what ground am I saying that there is no dominion and control over the interest income which the intermediate company was receiving from Indian company. So for a particular fact pattern, the AO was not able to establish that the intermediate company is shell or a conduit company. The common grounds which the AO says that AO held that the investment made by the appellant in the company is a back-to-back loan on the basis that it had used the shareholders' loan raised from the immediate shareholder to invest in the company. It was merely acting as the conduit company for the passage of funds between the immediate shareholder and the Indian company. Further, it says that the intermediate company had even outsourced its key function like company secretarial function, and it is merely a nameplate company. These are sort of allegation which the AO generally makes for such sort of transactions. And it said that it is incorporated in tax haven and does not have any independent office or the qualified employees to carry out the business of the investment activities, and hence you are not the beneficial owner. First of all, there is a back-to-back arrangement. It says that you have received loan from shareholder and you have directly applied that loan to give to invest in CCDs of the Indian company. Now let us see what all were the arguments with the assessee advocated in support of his claims. The assessee submits that in the act and in treaty there is no definition of the beneficial owner, so its ordinary meaning should be employed. In its ordinary meaning, the meaning of the term is that an entity which is the legal owner of property, in case of this is the interest income, and who owns dominion and control over the property. The owner who holds the property on his own account, for he being the legal owner of the property, and not as the agent, not as the trustee, or not as the nominee for some person. So he said that I am owning the investment on my own account. I am taking the risk on my own account. I received loan in USD, but I am investing it in INR. The rate of interest and the interest income is all mine. How I am able to repay my interest to my shareholders is not a question. It is altogether a different transaction, and there is nothing in that agreement to state that the income from my proceeds should be used only for your purpose for repayment of your loan. There is no such clause in this. So I am taking certain degree of risk by investing in the Indian capital market, and I am also taking the risk by taking loan from you in USD. So there is a sort of currency hedging which is taking place, and this is a specific question on TRC as well. So he said that I am also holding tax residency certificate. So once you have a tax residency certificate, you cannot question that I am a resident of a particular contracting state or not. So this was also the argument in this particular case. the tribunal in its judgment over here said that fine, I agree that the loan was taken from the shareholder with little interest or no interest, and it was also financed by a share capital which the shareholder has given. But there is no back-to-back arrangement, or the mere fact that investment was funded using the portion of interest-free shareholder loan and share capital does not affect the appellant's status as the beneficial owner of the interest income, as the entire interest income was a sole property of the appellant. This they have also given the reference of OECD 2017 commentary and on Article 11, so which says that where the recipient of interest does not have right to use and enjoy the interest unconstrained by the contractual and legal obligation to pass on the payment received to another person, the recipient is the beneficial owner of the interest. So when there is no back-to-back arrangement for passing on the interest, in such a case you are a beneficial owner of that interest. So in a nutshell, the three parameters which the tribunal has in short put a focus on while determining whether for a particular fact pattern you are a beneficial owner or not are as follow. So the appellant was required to seek approval or obtain consent from any entity to invest in ABPL or utilize the interest income received at its own discretion. This should be parameter which one should look upon. The appellant was not free to utilize the interest income received at its sole and absolute discretion, unconstrained by any legal, contractual or economic arrangement with any other third party. So in a view of a particular fact pattern, the transaction between the foreign company and the Indian company cannot be considered to be a merely back-to-back transaction lacking commercial substance. So in this regard, mainly focusing on the OECD commentary, the tribunal has held in this favor. However, in the particular our BEPS era, it will be more relevant to see how does this judgment is more helpful. I think this limited things will not be that much useful. Documentation needs to be maintained well, and demonstrating the economic substance will be more crucial. Thank you friends. Have a great day. In case of any query, please feel free to contact.